So what I'm going to talk about today is that I often get asked, what's the next step in the process as I've been charged with a felony? And it's one of the scariest things that a client is going to have to go through, is that initial shock of how things are going to go, looking forward into the future, what their life is going to, what's going to happen. And the first thing that's going to happen is you get arrested on a felony. You're going to normally get brought before a judge very soon afterwards. After you're at the police station, the police are going to give you a copy of what they're charging you with, and they're going to take you to court. You're going to be brought initially to one of the local courts in your jurisdiction. Here in Broome County, for instance, you'd be brought before one of the local court judges, depending upon where the crime is alleged to have happened. Let's say, for the sake of argument, the town of Vestal. So you'd be brought, if some felony was alleged to have happened somewhere along the Vestal Parkway, when you were arrested, you brought to the Vestal police station. The Vestal police would, in all likelihood, bring you in front of a Vestal town court justice. At that time, when you're going to be brought into Vestal, you're going to be arraigned on that felony. And what that means is that the judge is going to give you, again, a copy of what you're being charged with. Let's say it's a copy of a felony complaint that's charging you with grand larceny in the 4th degree. The judge is going to say, Mr. Jones, how are you going to plead to a count of grand larceny in the 4th degree? Now, because it's a felony, and because you're in the local court, by statute, you can't enter a plea to a felony in the local court. So the only plea that you can enter at that point is a not guilty. And generally, if a client or someone who doesn't even have an attorney yet goes in front of a judge in the local court, the judge is going to just enter that not guilty plea because that's the only plea that they could enter. After the not guilty is entered, then what's going to happen is the judge is going to consider the issue of bail. Now, I've talked about bail previously, but the idea of bail is to determine whether or not you're a good risk for the judge to let out, and that you're going to make, and is he willing to bet that you're going to come back to court when he needs you to come back? So some of the factors that he's going to be considering are what your criminal history looks like. Is this your first offense, or is this your 5th offense? Have you ever been upstate before? Do you have any prior prison history? Have you ever been in jail before? What's your work history look like? Are you working locally? Or are you somebody that's passing through town and really don't have any ties to the community? Are there any type of addiction issues, mental health issues? All of these types of things factor into the judge making a determination as to whether or not you're a good bail risk. On higher level felonies, E's or D's or above, what's going to happen is the judge may want to hear from the district attorney's office. The DA's office has a right to be heard on certain level felonies. So what sometimes happens is that the judge will actually contact the prosecutor and ask for a bail recommendations. I used to be a prosecutor before I started our own practice, and as a prosecutor I can tell you, late at night you'd get calls from local court judges who would ask you questions about, this person just was brought in on a felony DWI, or this person was just brought in on a burglary in the 2nd degree, which is a violent felony. And you have to give, as a prosecutor, you're going to be given a recommendation to the judge as to whether or not you think this person who's alleged to have committed this crime is going to be, you think that bail should be set, or you think that they should be remanded to the Broome County Jail. Oftentimes what's going to happen is that on the lower level felonies, a lot of times those people, the judge will let them out on low bail, or will ROR them or release them in their own recognizance. But on the higher level felonies, generally, especially on a weekend, you get arrested on a weekend, you're in all likelihood going to be remanded to the Broome County Jail or the county jail where you're alleged to have committed this crime. the next thing the judge is going to consider is you have certain rights if you've been remanded to the Broome County Jail in this instance, in our example. Once you're remanded, once you're in custody, you have a right to something called a preliminary hearing. And what a preliminary hearing is it's an opportunity for the district attorney's office has to put on a specific amount of evidence, reasonable cause to believe that a certain felony was, or a felony was committed. And that evidence has to go on in front of the judge. You as the accused and your attorney have the ability, should you want to, you can come in and then cross-examine the state's witnesses. You have the right to testify on your own behalf, and your attorney is able to then defend you both in cross-examination, opening statements, closing statements. You can put on your direct case and make arguments to the judge as to why you don't think there's sufficient evidence to hold you in custody. One of the things that clients sometimes have a hard time understanding is the idea of the preliminary hearing is such that the preliminary hearing doesn't prove your guilt or innocence. Okay? The preliminary hearing, the point of the preliminary hearing is the DA's office has to give you that hearing in that 120 to 144 hours of the point that you're going into custody. If after hearing the evidence, the judge finds that there has been sufficient evidence to show that you committed some felony, then what happens is that your case is held over for grand jury review. So you're held in custody at that point. If, however, after completing the preliminary hearing and after the judge gives you a decision, the judge finds that there was insufficient evidence to show that you had committed some felony, the case doesn't get dismissed. What happens is that you get released from custody, which in your case, or your specific case, that could be a big deal, obviously. It can be helpful in certain circumstances to have a preliminary hearing. Sometimes it's nice to be able to kick the tires and look at the case right up front so that you have an opportunity to see what the police officers are going to testify to, see what the other witnesses are going to testify to. You lock them into a certain story. You're creating prior testimony that your attorney can use down the road at a subsequent hearing or trial. So sometimes that can be very helpful. On the other hand, it can also hurt you a great deal. Testifying at a preliminary hearing or even having a preliminary hearing can be detrimental to you long term, because in some counties they don't want to have a preliminary hearing. So what will happen sometimes is if you request a preliminary hearing, the district attorney's office may not give you discovery. So copies of the police reports, copies of witness statements, and so on may not be given to you. That type of information, although you may be entitled to at some point down the road along the process, you're not entitled to right up front at the time that you're arrested. So if you go forward and ask for a preliminary hearing, they may not give that to you. Secondly, they may not offer you or extend to you an offer before grand jury. An offer by the DA's office is not something you have a right to. You don't have a right to get an offer on a case. People sometimes think that plea bargaining is something that you have a right to, and it's not. The DA's office could say, he's asked for this preliminary hearing, we're not only not going to give him police reports, but we're not going to extend to him a pre-grand jury offer. That can make a big difference in a case. Sometimes on people who have a prior felony conviction and whose exposure is heightened because of a new felony, you may not want to get indicted. Your offer, your mandatory minimums as far as state prison is concerned, could be elevated because of being indicted. You could be locking yourself into a specific situation that may be detrimental to you long term. So the ideas of having a preliminary hearing or reserving your right to a preliminary hearing is something that you'd want to talk to your attorney about. And that's something that we could help you here with at Jackson Bergman. So anytime you get into those types of questions that can have a significant impact on your case and on your criminal case is something that you want to be talking to your attorneys about.